Let's talk about the contours and the parameters of how we got here today. We're going to bring into the conversation right now our friend legal analyst, Cully Stimson. He joins me. And Cully, good to see you. I know you've been following this case extremely closely here. Penny's attorneys argued all along that he was protecting himself and other subway passengers from a volatile, mentally ill man in Jordan Neely who was making alarming remarks and gestures here. I want to talk about the jury in this because from some of those advocates, they leveled the charge and alleged that this was a biased, racist jury. The jury was anonymous. Why was it anonymous in this case?
Well, I think for the exact reason that there'd be the potential that if the verdict turned out in a way that the Black community didn't like, they would call them racist and threaten them. And not only have these people, now that the jury returned the proper verdict, in my opinion, threatened Mr. Penny and told him he's not welcome in the city. And they threatened him live on TV. But you can imagine that the jurors themselves didn't want their identities known. And by the way, this was a mixed race jury and a mixed gender jury. There were Black people on this jury. So unless they think Black people are racists, I think they're missing the boat here. But obviously, this is a verdict that has drawn the passions of people. They're trying to connect what happened to Mr. Neely, who was clearly a person who the criminal justice system failed to hold accountable for his many crimes and his mental health problems. His family abandoned him a long time ago. He should never have even been on the street. But regardless, he's dead. And he's dead not because of what Mr. Penny did, but because of, at least competing medical experts, because of an intervening medical event after he was restrained by Mr. Penny. So he's not a civil rights hero. Like a lot of these people who are held up as civil rights hero, he's not a civil rights hero. It's a sad thing that he's died, but he didn't get the treatment and services he needed and accountability that was required to keep him off the streets.
Okay, Cully, let's talk about this now. Neely's father filed a civil lawsuit against Penny here. What's the likelihood of that gaining steam? Now with this acquittal, could we see civil litigation go in the favor of Neely or Penny here? How do you see that?
Well, remember that the standard of proof at a criminal trial is beyond a reasonable doubt. But the standard at a civil trial is much lower. It's clear and convincing evidence. And so much of the same evidence that was put forward in this criminal trial will be used in the civil trial. And you just don't know how these civil cases will play out. Remember, years ago, O.J. Simpson was prosecuted for murdering his ex-wife and a young man, and he was acquitted in the criminal trial, but he was held accountable in the civil trial in order to pay tens of millions of dollars in fines, which apparently he didn't pay. So I don't know how this is going to play out, but they've already filed the suit. And no doubt they're going to try to get some money out of Mr. Penny or people who back a Penny civil defense fund if there is a judgment.
So just on Friday, the more serious charge in this case, the charge of manslaughter, was dismissed by the judge, and that was after hours of deliberations by the jury. The jury told the judge they could not reach a unanimous verdict. They were deadlocked on that. And so we got the news, we brought our viewers Friday, that charge was dismissed. The charge at question today the jurors had to deliberate on was criminally negligent homicide here. So there was no mistrial. In this case, you were hearing, whether or not a mistrial would be declared going into the weekend. The judge invited the jurors back today to deliberate on the remaining charge here. So that specter of mistrial went away pretty fast, didn't it?
Well, it should have happened last week because, frankly, this judge and this prosecutor committed numerous errors that if he'd been convicted of either charge, he would have probably been successful on his appeal years down the road. I mean, the judge under New York law, when a jury comes back and said, I'm sorry, Your Honor, we aren't able to reach a verdict, the judge gives them what's called an Allen charge, which basically says, turn around, go back in there and try to sort it out. They did. They came back and said again, I'm sorry, Judge, we just can't come to a verdict. At that point, he should have declared a mistrial. He didn't. And realizing that he wasn't going to grant the mistrial, then the prosecution took a gamble. They rolled the dice and they did something that they shouldn't have been allowed to do, which is they asked the judge to dismiss the top charge. Most judges, and I've talked to New York State trial judges over the weekend who are friends of mine, and they said, no, the judge should have said, absolutely not. This is too late in the game. You cannot do that. But the judge granted it, which is essentially a coercive verdict because he's now focusing all their attention on the remaining lesser included offense of criminally negligent homicide, gave them the week to cool their jets, and then told them to go back and deliberate on that. On top of that is this prosecutor who made numerous allusions to the decedent's race, which had nothing to do with the gravamen of the crime. So it was meant to inflame the passions of the jury or the people outside the courtroom to force the jury into a verdict. But look, criminally negligent homicide requires you to either be reckless, inattentive, or careless, and that caused the death of somebody else. Penny was not reckless, he was not inattentive, and he certainly was not careless. He was careful to protect himself and others. And under New York law, that's a complete defense, and this jury saw it that way too.
Yeah, I mean, Cully, I thought it was so interesting. To your point, this was not the defense requesting the dismissal of the more serious charge. This was the prosecution, and I wanted to reiterate that point here. Let's talk, though, about the possibility of a retrial on this charge of criminally negligent homicide. Does the acquittal today foreclose any possibility of a retrial on both of these charges here? Do you envision that happening, or no, he was acquitted?
Well, remember, this is America. It's not England. It's not France. In France or England, the government can appeal an acquittal. But we broke away from Mother England and rejected that. So the double jeopardy clause prevents a retrial on criminally negligent homicide because the jury rendered a verdict and because the prosecution requested the dismissal of the second-degree voluntary manslaughter and the judge granted it. Jeopardy attached there as well. So double jeopardy prevents the retrial on any of those two charges. Maybe Bragg could try to be creative, and I use that in air quotes because he's been an abysmal elected DA, and try to find something else. I just don't think it's possible because anything he would try to charge them with would have to be facts separate and distinct from the fact in the subway, and there is nothing else. And so I think for all intents and purposes, the criminal charges are over at the state level.
So, Cully, I wanted to ask, I mean, should DA Bragg have brought this case in the first place here? I think I might know the answer that you're going to provide and others in your kind of orbit and cohort who don't believe Bragg should have brought this case. Why not?
Well, the reason that we dedicated one of the 8 chapters in our book called Rogue Prosecutors, How Radical Soros Lawyers Are Destroying America's Communities about Alvin Bragg is because he views the world, just like the other 70-plus Soros bought and paid for rogue prosecutors, through race-colored glasses. And I think a lot of people have said, you know, had the decedent been white, Bragg likely wouldn't have brought this case. That might be true, and I think that probably is true, sadly. But the thing is, look, holding somebody accountable has various means. One of the means is bring them in for questioning, wait for the medical examiner's report, look at all the evidence, including video evidence, look at all the cell phone evidence, and then decide not to take it to the grand jury. That's holding somebody accountable because your life is in the balance at that time.
Okay.
The fact that it had to go all the way through what it did with the shenanigans that the prosecution pulled and the judge's missteps, and we finally end up with the proper verdict here, was a miscarriage of justice, in my opinion.
Okay, and we're kind of diving into some of these hypotheticals here, but I want to stay with this case and what transpired. Daniel Penny, at the end of the day, though, did take the life of another human being. So no penalty or some penalty. How do we adjudicate that as a culture in the court going forward? Or was it done today?
He restrained a violent, erratic, mentally unstable person who was threatening the lives of other people on the subway. He did it. He did it at great risk to himself. He suffered the consequences of a criminal trial that most DAs would not have brought. But the medical examiner on the defense said that his restraining Mr. Neely did not, in fact, cause his death. The death was caused by an intervening medical condition that Mr. Neely had. So I think it's an open question as to what caused the death of it. death of Mr. Neely. But regardless of the fact, I'm sure nobody, including Mr. Penny, is happy that Mr. Neely has passed. I was a homicide prosecutor. It's never a good day when somebody dies, whether it was criminally negligent homicide, second degree murder, first degree murder, or just somebody did something, it was lawful, and the person died. It's not a good day when somebody dies, especially on the streets, not from natural causes. And so, I don't think that Mr. Penny is dancing a jig. I'm sure he's greatly relieved.
Yeah.
And even people who are acquitted in trials through self-defense or an imperfect defense, they're not thrilled that the person died. They're happy that they weren't found guilty.
Yeah, Cully, I wanted to ask, though, about the self-defense argument here and that word vigilantism. And you heard there in that press conference of many of Neely's supporters essentially say, if Daniel Penny is going to get away with it, we need our own vigilantes to protect ourselves, i.e. the black population here. That's not the right approach, is it?
Obviously not. I mean, they're angry, but they should turn their anger towards the very prosecutors who have unleashed holy hell on these cities and whose policies have caused more black people to kill more black people.
Okay, but Cully, Cully, I'm asking, even if you're Daniel Penny, though, and you see this going on in front of you on the New York City subway, should you think twice about acting?
Sure. Yeah. This does not give people a green light to take the law into their own hands, but it also doesn't. It also should tell people to use their common sense. If I'm standing there with my girlfriend or my wife or my daughter and a nut job who's clearly insane, telling he's going to kill people and it doesn't matter, and he comes after one of them or tries to strike them, I'm going to defend my loved ones. Daniel Penny took an action that most people wouldn't have taken, but he did it because he thought he was going to help other people. So I hope that the people who are calling for vigilantism cool off and don't do anything that they're going to regret that would harm other people.
All right, Cully Stimson, as always, thanks so much for your insight and your expertise. We'll talk soon.
Thank you.